Thank you for being here. And as most, but maybe not all of you know, my name is Greg Bowman. I am the Dean of the College of Law. It is my enormous honor and privilege to be in that position. And it is my distinct honor to welcome you to this afternoon's annual C. Edwin Baker Lecture for Liberty, Equality, and Democracy. The Baker Lecture is one of our premier annual events at the College of Law. It was established in 2010 through the generosity of the family of the late Professor C. Edwin Baker, who was one of the nation's leading First Amendment scholars and who was a teacher, mentor, and longtime friend of our WVU law faculty colleague, Ann LaFosse, here in the front row. The Baker Lecture celebrates the life and legacy of Professor C. Edwin Baker, who was known to his friends and family as Ed. Ed was a brilliant scholar in the area of liberty, democracy, and free speech. He served as the Nicholas F. Galicchio Professor of Law and Communication at the University of Pennsylvania Law School, and he was a leading scholar of constitutional law, communications law, and free speech. Professor Baker was one of our country's foremost authorities on the First Amendment and on mass media policy. So each year, in his honor, we bring to campus a leading commentator on the areas of liberty and equality and democracy, and our university community and our state are enriched by this very meaningful annual event. And the College of Law is really very proud to be the home, the place to celebrate Professor Baker's scholarly life and to house his archived papers in our library. This is certainly true because of the subject matter and because Professor Baker's scholarly legacy is worth celebrating, but it is also true in a very real and profound way. Professor Baker's life and legacy should serve as a model for us all. As scholars and teachers, all law professors strive to make a difference in the world, and we strive to do so one student, one future lawyer and leader at a time. As students, all of us strive or have striven to excel, and the teacher-student relationship can be a deep and profound one. It can be life-changing for both the professor and the student. And Ed Baker had a profound impact on his students, including on Dr. LaFosse. He helped her shape her worldviews and her own jurisprudential theories. She talks lovingly of Ed Baker. I know that she impacted him as well. He considered her a friend and a peer. So the fact that we host the Baker Lecture here at WVU serves as a reminder and indeed as a celebration of the transformational power of learning in our lives, both as students and as teachers. And it's also fitting that WVU hosts the annual C. Edwin Baker Lecture because Ed Baker valued family, and he believed that the word family extended beyond blood or adopted relations. Ed grew up in Kentucky, near West Virginia, and the struggle for civil rights and racial equality were hallmark features of his youth in the 1950s and 1960s. His parents, Falcon O. Baker Jr. and Ernestine M. Baker, were strong supporters of the civil rights movement, and they instilled in their son Ed a passion for justice that was a hallmark feature of his scholarship and of his teaching. And we at WVU Law, of course, share those values. Professor Baker died too young, but his legacy does live on in his scholarship and in the students whom he mentored, and he is a wonderful example for all of us to try and make it count and to live a life filled with meaning. So here we are today, brought together by Ed Baker to honor his memory because he believed in the individual, in justice, and in the power of ideas. So thank you again to the Baker family for allowing the WVU College of Law to be a home to his legacy. And thank you to Dr. LaFosse, who helped bring this legacy here to WVU Law. I will now turn the podium over to her. You can say a few remarks and introduce our speaker. Thank you.
Good afternoon. I'm Ann LaFosse, and I was just telling the dean as I was stepping up here, thank you for such a wonderful introduction to the Baker Lecture. I feel the dean really captured Ed's essence, and I so appreciate that. So thank you so much, Dean Bowman. Hugh Collins is an accomplished man of the law. You can read about his career and his many achievements in the program, and I urge you to do so. What I'd like to do today is to give you a personal account of Professor Collins and why his work embodies the values underlying the Baker Lecture. 27 years ago, I was in my third year at the University of Pennsylvania Law School, where I was focusing my studies on comparative labor law. One of my mentors, Clyde Summers, suggested that I apply for a scholarship so that I could extend my study of comparative law to a foreign jurisdiction. When I told him that I was interested in the European Union and England in particular, he suggested that I apply to Oxford. In his view, Oxford boasted not only the second best law faculty in the world to WVU's law faculty, but the best labor law faculty. Historically, there was Otto Confreud, who together with Clyde Summers created the field of comparative labor law. But there was also Mark Friedland, Confreud's former doctoral student, Paul Davis, Clyde Summers' former student, and two up-and-coming superstars. One was Sandra Fredman, who would become my supervisor, the other, Hugh Collins, both the equivalent of assistant professors in our system back then. Unfortunately for me, Professor Collins decided to leave Oxford for the London School of Economics the year that I arrived at Oxford. So I was left only to read his work with vague hopes of meeting him someday. That occasion arose nearly 2 years ago, when I returned to Oxford to work with my former supervisor, Sandy Fredman. This time, Hugh Collins was back at Oxford as the Vinerian Professor of English Law and is thus sitting in the very same chair that William Blackstone occupied exactly 259 years ago. And when I mean exactly, he was appointed on October 20th and gave his first lecture on October 24th. So we're pretty precise here. Now, many of you are 1Ls and may never have heard of William Blackstone, but he is a name that you will get to know in your 3 years of legal education. William Blackstone is perhaps most famous in US legal education for authoring the Commentaries on the Laws of England, a 4-volume treatise of English common law originally published in the 1760s, designed to explain that law in plain language accessible to the non-lawyer. Although initially controversial in its time and met with skepticism by many common law lawyers as a surreptitious attempt to codify the law, the commentaries eventually became accepted as one of the most significant triumphs of legal scholarship. As a readable and handy treatise of the English common law, English colonies and former colonies such as Canada and the soon-to-be United States could more readily incorporate and adapt principles of English law into their own emerging legal systems. My first meeting with Professor Collins is quite memorable for me. I noticed that he was teaching comparative labor law course, which met once a week. I showed up to the first meeting of that class, introduced myself, and asked if I could audit. Specifically, I said, "It would be an honor to audit this course with you, sir," in a tone that one should probably reserve when meeting a teenage idol, such as if my 13-year-old daughter were to meet Harry Styles of One Direction. Professor Collins quite rightly looked at me askance and said quite humbly, "It's only comparative labor." In getting to know Professor Collins over 6 or 7 months in 2016, I can see now why he'd be so uncomfortable with my reverential idolatry. He is a humble man who does not boast of his many accomplishments. It was through those conversations that I thought he'd be perfect as a Baker lecturer. There is one of Professor Collins' achievements that I would like to share with you, though. In addition to being an internationally renowned scholar, Professor Collins is also the former dean of the London School of Economics. During his tenure, LSE Law moved up the British research rankings to #1, surpassing his alma mater, Oxford, a move that Oxford stopped by stealing him back. With that, please help me give a warm West Virginia welcome to Professor Hugh Collins.
Well, thank you very much, Anne. Little did I think that when you showed up in class that I'd end up here. What a pleasure it is. Blackstone gave those lectures because he was paid really badly by the dean, and he realized the way to make money was to hold some public lectures and the students had to pay a few pennies when they came into the room, and he had his hat there collecting the money. But today's free, don't worry. Now, it's a great pleasure to be here, but it's also going to be tricky because I haven't practiced on this machine. But it's also tricky because most of you are just starting law, but there's some who've been studying law even longer than I have. And to find a topic that's going to be of interest to you all is tricky. But what I wanted to do, what I'm going to try to do is have a very big picture kind of discussion, but every now and again hone in on a few cases so you can see how the big picture pans out in detail. And I want to introduce you to a word that's popular in Germany, and we've sort of picked it up elsewhere. The phrase, the Constitutionalization of Private Law, although we still haven't decided whether it's spelt with an S or a Z, and I think you'll find I'm inconsistent in these slides. And the very basic idea here that I'm going to introduce you to, the very basic idea is that there's two areas of law, public and private law. And public law, by which I mean constitutional law, administrative law, and some other aspects which you haven't studied yet, which you've heard of the US Constitution, the US Supreme Court, I assume, so we'll take, you have some idea of what that's about. And it's about the relationship between that part of the law and the other part of the law which you are studying, like torts, contracts, property, and how they interact. And what the theory of the constitutionalization of private law says is that the contract, tort, and property law bit have to be designed and developed by the judges in a way that aligns with constitutional rights. And this word alignment is very carefully chosen, and indeed it refers, oddly, to some standing stones that are a great mystery that are found in Brittany, in western France, where in these fields they go for miles, these standing stones, and they create these 2 or 3 kind of roads between them. These stones are about 6 foot high, and nobody knows why they're there. I mean, it's possible they were there for some ceremonies or something like that. Maybe it was for horse races, who knows. But the idea is that the rules of private law, like contract, tort, and property law, those rules should be aligned. In other words, always be in line with fundamental rights, the sorts of constitutional rights that you'll be studying, unfortunately, next term. So what does this alignment mean? If you want to put, there's a bit of jargon coming up, sorry about this, but the courts have got to interpret and develop private law, like contract law, tort law, property law, which here will be state law, I imagine, and in a way that conforms to, aligns with, is consistent with and coherent with constitutional law, which here might be state constitution, if you have one. I've meant to look that up, but also certainly the US Constitution. In other countries, the technical approach is slightly different, but the general idea is always the same. In the United Kingdom, we have something called the Human Rights Act, which requires courts to align private law with the European Convention on Human Rights. So, and in the European Union, which has nothing to do with the European Convention on Human Rights at all, the European Union, it has its own convention, though it calls it a charter. And the European Union institutions, which Britain is about to leave, they have their own charter, and their European law must conform. And it's also possible in Europe for individuals to go off to a court in Strasbourg called the European Court of Human Rights and complain that their government is not protecting their rights. So you can just go off to this, in some sense, foreign court and claim. And the jurisdiction of the European Court of Human Rights is very broad. It includes unlikely countries like Russia, Turkey, we'll see some other, Romania, where human rights are not necessarily very strongly observed. When you get to do constitutional law next term, you will study, I suspect, a case called Shelley and Craver, which is a case that illustrates exactly what I'm going to be talking about. No, they haven't seen Shelley and Craver before. So what happens in this case is briefly summarized there. An African-American family called Shelley buy a house, buy their home in St. Louis, Missouri. And they're unaware that there's some property law arrangements there, private contractual arrangements called restrictive covenants, which include a term in when you buy the property, which binds the new owner of the property and the seller, which says that which said in this case, back in 1945, that the property couldn't be owned and occupied by people of Negro or Mongolian race, which of course the Shelleys were. And a neighbour brings a case saying that this is a breach of the restrictive covenant, a breach of this aspect of property law to allow these people to live there, and that they should be evicted. And what the courts, the local courts in Missouri say, yes, that's right, it's a property law case, there's been a breach of property rights, therefore this family ought to be evicted. But then the case ends up in the US Supreme Court, and they make this quite complicated maneuver, which I'm going to call indirect effect. It's just a bit of jargon, but what they say is, yes, the property law is clear. The property law entitles the neighbour to insist that this black American family should not live in his neighbourhood. That's a property right he's got. But, says the Supreme Court, no court should enforce this contract because it interferes with fundamental constitutional rights. Okay, so the property law is clear, but it mustn't be enforced by a court because a court must uphold the Constitution, and the Constitution says that this kind of discrimination is going to be unlawful under the 14th Amendment, which you haven't studied either. They're looking very puzzled, and the faculty are looking like I've got it wrong. Another case, which presumably Baker wrote about at length, New York Times and Sullivan, which is a case about, it was an advertisement in the New York Times, which is up there, but impossible for you to read, I expect. But this advertisement claimed that the police department in Alabama, Montgomery, Alabama, in the early 60s had done all sorts of dreadful things to civil rights protesters, and it contained a number of inaccuracies. Like it said, for example, that Martin Luther King had been arrested 7 times, whereas in fact it had only been 4 at that point. It was 7 a few months later, but not by then. So there are lots of inaccuracies in this story, and a local person, a government official who was responsible for the police, thought that this was a defamation of his character. So, which it was. There were untrue statements about him which suggested that he was running the police force in a very improper, arbitrary manner. And some of the claims were untrue. So there was a defamation claim, but the case is eventually taken to the US Supreme Court, and the court says, yes, well, there is a defamation claim, a tort claim here, that's right. And in principle, that claim should be successful, but the law of tort here, the law of defamation, must be interpreted and developed in a way that is consistent with the Constitution. And they say that the right to freedom of speech is very important, as well as the right to have your reputation protected against false stories. And in balancing those, they conclude that the proper way to balance or align the different rights is to say that there will be freedom of speech for the newspapers unless their statements are malicious, by which is meant deliberate falsehoods. So if the newspaper knows it's lying, then they're not protected. So what's happened in this case is the law of tort, defamation, has been developed in a way so that it is aligned with the law found in the Constitution. I should tell you, these cases are found by American scholars of constitutional law to be a bit odd. They're not quite sure what's going on here, because usually the constitutional law cases involve state action, actions by states or the federal government. But these cases don't. The only state action is the court enforcing private law, tort, contract, and so on. That's the only state action. Hope I'm allowed to mention one English case while I'm here. One, just MacDonald and MacDonald, nothing to do with restaurants. It's a sad story, and I thought the case was going to go the other way, but I was wrong. So there was a young woman who was severely disabled, and her parents decided that what they should do would be to buy her a home suitable for her, where she could live on her own, and she had mental disabilities and some physical disabilities. So they bought this home and they borrowed some money from the bank to buy the home, and they had to repay. And then unfortunately, the parents became unemployed because of the crisis, the subprime crisis. Though this wasn't a subprime mortgage, I don't think, but unfortunately they lost their jobs or were unable to make the repayments on their mortgage. Use the word mortgage? Yeah. So the people who'd lent the money, the bank, were then entitled to foreclose on the mortgage. In other words, evict the disabled daughter, who technically was a tenant of her parents, evict her and then sell the property. There was no doubt that their property law rights were absolutely correct. The bank had written a good, safe contract, and there was no way that the daughter could keep her home in these circumstances. But of course, this was a very sad case. You've got this disabled young woman who can't cope on her own, being thrown out onto the street. So she complains that the law, as interpreted, was not being interpreted in a way that aligned it with her constitutional rights, which in Europe include a right to a home, a right to possession of a home. And she was clearly losing her home. So we have a constitutional right there. And the court agrees, the Supreme Court, which is our top court, agrees. In Britain, the court said yes. what we have to do is make sure that the law is aligned, that she has a right to her home, but of course the bank have a property right, which includes exclusive possession. They can throw her out. So they had to balance those two rights. And I thought they were going to balance the two rights in her favour, but not a bit, no. Our court is fairly conservative. They said, no, the landlords must always win in these cases, the banks must always win. We've got to protect property rights, even if there's a sad case where a young woman with disability loses her home. Okay, so we lost, but the principle was there, that the property rights had to be interpreted in such a way as to respect her right to a home. So I've been giving you 3 illustrations of what I mean by alignment, or sometimes the jargon of indirect effect, and this is a very controversial development in Europe, just as it is in the United States. People write long articles about Shelley and Craver and how constitutional law could be relevant to property rights. And it requires, it's good for law professors, but bad for practicing lawyers, I think, because it means there's an additional stage of the legal reasoning. So you work your way through all the contract law or the property law or the tort law issues. You get right on top of it. You work out what the result should be in property law, tort law. And then you've got, just when you think you've finished, the bank wins or something like that, you then start a whole new game, which is you have to ask yourself, but is this result consistent with the rights of the parties? The fundamental constitutional rights. And if you're in Europe, you've got quite a lot of choice. You can have your state constitution, and the European Union sometimes, and the European Charter of Human Rights. And here in the United States, presumably you can look at both state constitutions and the federal Constitution of the United States. So there's lots of opportunities there. And lawyers get nervous about this because, understandably, they think they know the law, they're an expert on property law, and then it turns out they don't really know anything at all, because once they've done their property law, they then have to say, oops, there's maybe a public law element here too, a constitutional. And this generates some considerable fear. I've sort of bullet pointed some of the things that are controversial. One of my colleagues in Oxford just regards this as the end of civilization as he knows it. He's a contracts lawyer, and the idea of having to know anything about constitutional law is really scary stuff. And he thinks it's just going to mess up his very clever, tidy analysis of contract law. In other words, he's going to have to rewrite his horn book. It's horrible. It's also more sophisticated, saying that he's worried that actually we've spent several hundred years in contract law, both here and back in Britain, trying to work out what fair results might be. Just when we thought we'd got it mostly sorted, along come these people brandishing human rights, fundamental rights, saying, no, you've got to have a rethink. And people are worried that this will just upset the law as we know it. And then, of course, within the law faculty, I'm a sort of a private lawyer, yes, interested in contracts and things like that, and employment. And we're always very worried about the imperialism of our constitutional law friends who seem to think they know about everything. So we tease them about that. And there are doubts about whether this is a good idea. And then the last bullet point is quite tricky. So let's go back to Shelley and Craver. The property owner there who doesn't want his neighbours to be black and has got a contract, he's paid money to ensure that that's going to be the situation. He says, well, it's okay if the government and judges and so on, they have to comply with the Constitution, but why should I? This is political correctness. Why can't I don't want to be under a duty to behave in a kind of constitutionally proper way all the time. I want to be able to choose my partner on the basis of race discrimination or sexual orientation discrimination. This is my personal choice. I shouldn't have to behave like the government. The government must behave properly and treat everybody equally and comply with rights. But why should I, as a private individual, do that? Because that's the effect of Shelley and Craver, I think. So I'm going to take you through fairly rapidly 3 steps in what I want to say about this controversy of the constitutionalization of private law. And there's my claim, the thesis. So I'm going to say all this worrying about the disruption to private law caused by the requirement to align private law with constitutional rights, this is all a bit overblown. It's not such a big deal, but that sometimes I think it's a good thing. When I look at Shelley and Craver and New York Times and Sullivan, I think actually these were good decisions. They did disrupt private law. The private law rights were rewritten, but that was a good thing. And these small changes are necessary sometimes. And in order to comment on that and try to persuade you of this view, which is certainly not orthodox, don't put this in your exam, this is not orthodox stuff, I need to just take you through a few little steps in the argument. One is just talk a bit more about this public law, private law distinction. And this is tricky because the 1Ls have not done what I would call public law yet. It's just private. And then I'm going to try to argue that the disruption, though not nugatory, the disruption to private law, contract, tort and so on, is in fact fairly small. And thirdly, I'll just give some examples of where I think it's been a good thing, although I've already given you to the Shelley and Craver and New York Times and Sullivan. I thought yes. So this slide doesn't need to be there. I'm just saying, in the good old days of Sir William Blackstone, my predecessor, they didn't really have this distinction between public law and private law. It was the common law. And the idea was that everyone had to comply with the common law. And that's what something called Magna Carta was about. It was saying that even the king had to respect people's property rights and liberties. The king wasn't above the law, nor were the nobles and so on. So the common law, which included rights, had to be observed by everybody. There was no real difference between public and private law. And that's always been an orthodoxy of in Oxford law professors, including 2 of the famous ones, Blackstone and Dicey. Blackstone writing in the commentaries, which were written, of course, before you rather abruptly left the United Kingdom. And so when he writes about this kingdom, he's including the whole of the colonies in the United States. He says in his beautiful style, the idea and practice of political or civil liberty flourished in their highest vigor in these kingdoms. He's referring to Scotland, Ireland, and you lot here, where it falls little short of perfection and can only be lost or destroyed by the folly or demerits of its owner, which is its Parliament. He thought the judges upheld the common law and the rights of everybody. The only danger was from Parliament, the legislature. Of course, it's little short of perfection. We need to remember at this time that women didn't have any rights, and they were just essentially owned by their husbands. And of course we had slavery and so on like that. So it was a little bit short of perfection, a little bit, but the pride here is genuine. He's saying the common law does protect everybody's rights against everybody else. So in those days there was no clear distinction about, there was no requirement of state action or anything like that. But that view has been rejected since, and we now usually distinguish between constitutional law, administrative law on the one side, rules controlling government, which we call public law. These public laws also control quasi-governmental institutions on the one side, and then private law, which is essentially the rules governing interactions between private citizens, including corporations, where they make contracts, commit torts, enter into property rights, that sort of thing. We make that distinction. And in my mind, it works, and the way that distinction typically works is illustrated by this little picture where on the left-hand side, we have things in England, I live in one, called semi-detached houses. I don't think you have them in America, do you? So they're kind of completely separate. There's a wall right down the middle there, from roof to ground, which means that they're completely separate houses, but on the other hand, you have one wall that's common, the party wall. And on the left-hand side, the public lawyers live, and they have fundamental rights and constitutions and things like that. On the other side, there are the private lawyers, and they have their contracts and property rights and torts and so on. And they don't speak to each other. They're different households, same legal system, different households, except just sometimes the constitutional lawyers start shouting about how important rights are, but the private lawyers, like my colleague in Oxford, is like this little pussycat, can you see it? Just don't disturb. I don't want to know about these rights things. I'm sticking to my contract law. So that's the traditional view. The sort of view that's coming out of this idea of the constitutionalization of private law takes a different view of how the legal system looks. And it says that actually the whole legal system is derived from human rights. That at the bottom, everything is derived from this idea that individuals have rights. And out of that idea erupts various parts of the law, some of which we call property law, some of which we call contract law, some we call constitutional law, but it's all fundamentally based upon rights. And you'll find that view is very popular in some European countries, and for a while, in fact, was very much influential in Israel, interestingly. And in South America, you'll find this as well, that everything starts from the Constitution, the fundamental rights, and then things get subdivided. I don't actually believe the magma theory myself, that everything derives there. I don't think it makes much sense, and I'll explain very briefly why I don't think it makes a lot of sense. There are some rights which are really important. There's three objections. There are some rights that are very important in public law, like the right to a fair trial, which aren't very important in private law. It's true, you've got to be able to go to court in private law and enforce your property rights or whatever, but the right to a fair trial is not usually of great significance, for example. Also, secondly, rights have different meanings according to whether you're having a discussion about, say, a relationship between a citizen and the police and the relationship between neighbours. That your rights might have rather different connotations in those contexts. We might say that some sort of right the same right operates in both contexts, but it may mean different things. But the big difference is going to be always my third point, which is that invariably in private law cases, contract, property law cases, both sides have rights. Whereas in public law cases, the government doesn't have any rights. It doesn't have, the rights are on the side of the citizen to protect the citizen against the government. But in private law, both parties have rights. So in Shelley and Craver, there's the property rights of the neighbour, property / contractual rights, and the right not to be discriminated against by the people who bought the house. Always rights on both sides. So that leads me to think that the best way to think about the relationships is a brooding omnipresence, which is a bad joke, we don't need to go there, or what the Germans talk about. In fact, the German Constitutional Court says that the rights in the German Constitution have a radiating effect, like sunlight, on all of the law, both public law and private law. But it kind of warms the whole system, but the whole system's not derived from the rights. They try to make that metaphor. So I think that's probably about right. What we're saying is rights are always relevant, constitutional rights are always relevant, but they're just they're shining a light on your law, and sometimes you need to use that light, like the light on your mobile phone. Really, like last night I was taken out to a nice restaurant, but it was so dark I couldn't see the menu, so we got out our phones and had a look. But at least it was in English, so it was good. Second stage of my argument, which I think we need to zip over fairly fast. The response that's often made to the concerns of people like my colleague, the contract lawyer, when he says, I'm really frightened, is I don't want to go there with all these human rights, constitutional rights. I'm going to stick to contract law. That's good. We don't need any of these constitutional arguments. And a lot of people will say to him, don't worry, because it's all just going to be indirect effect, and that means you don't need to worry about it too much. That is, I think, false news. It is indirect, but you do need to worry. So going back to Shelley and Craver, they describe it as indirect effect. So they're saying, well, the property rights are clear. The neighbour wins, but the duty of the court is not to enforce the property rights because the court has a constitutional duty to uphold equality, equal treatment. That's indirect effect, but that shouldn't make my contract law colleague happy, because the result is exactly the opposite of what property law said. You've reversed the result by reference to the Constitution. So it really does change the law, and it's disruptive. So the indirect claim is that because it's only the courts indirectly enforcing constitutional rights, that it won't have a major effect. But I think it really does have a major effect. I'm just going to give you 3 quick examples. Well, I've used some European examples now. Naomi Campbell, I don't know if you've heard of her, supermodel. Her name is beside one of our most important tort cases. Campbell, she's suing a newspaper, the Mirror Group newspapers. And what's she suing them for? She's suing them for this photograph, actually. That's the photo. And it's a picture of her. She's clearly very happy. She's trying to stop the camera. It's a picture of her leaving a rehab place, where she's been going to get her off her drug addiction. And she doesn't want this photo taken because she's been telling the newspapers for the last couple of years she has no drugs problem. And the newspapers didn't believe this, and eventually some paparazzi got a picture of her. And they published this on the front page of the newspaper. Naomi Campbell's been lying, she does have a drugs problem, otherwise why is she coming out of rehab? She sues, but what's her claim? Can it be defamation? No, it's true. It's absolutely true that she has got a drugs problem. So there's no defamation there. So she says, well, what you're doing is interfering with my right to privacy. You're telling people about my private life, and I didn't want you to. I've got my hand up there. I'm trying to stop you doing this. You knew I didn't want everybody to know. Well, so she brings this claim, but she's got no claim in tort law. The established tort law does not give her a claim in these circumstances. There is no right to privacy. So she has no claim. So the case goes up through our courts, and the courts will say, you've got no claim, sorry. And then it gets to our Supreme Court, and they say, well, actually, you do have a claim. After all, the newspaper has the right to freedom of expression, that's true, but you have the right to respect for your private life. And in our jargon, Article 8 is private life, the right to privacy. Article 10 is freedom of expression. And the court says, well, the tort law must be developed to give you a right in these circumstances to bring a claim, to protect your right to privacy. And then we will, having decided that, we will then balance the newspaper's right to publish true stories, as it happens, exposing her as a liar, against her right to keep her private law private. And that was the issue on which the court couldn't agree, whether she should finally win, but they all agreed that she should have a claim. So what's happened there, a new tort is created by reference to the Constitution. So this is not nothing, creating new torts. It's not some little side thing. An employment law case. We have a party in Britain called the British National Party, whose policies are, well, you can see who their friends are. Where is he? So on the right-hand side is their leader, and then these are the people he venerates, right? Adolf Hitler and so on. And then there's a chap with a swastika tattoo on him. You can see what sort of group they are. They have really their only political policy is to remove all people who are not white from the country. That's their policy. They get quite a few votes, sadly. Anyway, this case was a case where there was one of their members had a job, and he was dismissed, basically because he was a member of this party, and the employers didn't, when they found out, they didn't want him to be an employee, so he was fired for his political views. He was called, oddly, Arthur Collins Redford, this chap, but no relation to me, I'm glad to say. And his claim was blocked by a technicality in this particular case. He hadn't been employed by the employer very long, otherwise he would have had a claim. He tried a different claim, which made me laugh. He said, well, if you fire everybody who's a member of my political party, this is race discrimination, because you have to be white to be a member of the political party. So this will be the race discrimination against white people. The English courts threw that argument out. That was too ridiculous. But so he loses in England. He loses the case. He's got no claim. This is the employer's dismissal. He has no protection against that. He goes off to the European Court of Human Rights as he can. I mentioned that early on, and wins where he has to win, because under the European Convention of Human Rights, you cannot the right to be a member of a political party is regarded as one of the most fundamental rights, and he's being dismissed for membership of a political party, that must be unlawful. So the law is changed, in effect, by the court so that he can bring a claim against being fired simply on the ground that he's a member of this political party. These are just examples of where this alignment really matters, makes a big difference. One last case, and I think maybe there's some others. This is a picture of Andorra, which is a little country in the Pyrenees between Spain and France. And an old lady owned a field or two in Adora, and she left it in her will to her grandchildren, in effect. And the will was interpreted by the Andorran court to exclude the person who appeared to be her grandson on the ground that he'd been adopted. So he had sort of been adopted, it's true, but and acted as if he was the grandson, but he wasn't a blood relative. And the other relatives complained that he shouldn't inherit because he wasn't the grandson really. And of course they're going to win in the Andorran courts because that's what the law would say. He goes off to the European Court of Human Rights in Strasbourg and says this is discrimination on the ground that I've just been adopted. And the court agrees. And they say, well, the will left by the grandma must be interpreted in a way that's consistent with human rights. And essentially the court sort of says, well, the interpretation has to be such that it almost reverses the meaning. The will looks like you have to be a blood relative, and they just say, no, that has to be interpreted in a way that allows the adopted grandson to interpret, because otherwise then the court would be enforcing a discriminatory document, a will. So it's the same as Shelley and Craver in a way. I'm running short of time. The most recent case, we have Barbulescu in Romania. Poor old Romania, they're always in trouble in the European Court of Human Rights. But I thought you'd be interested in this case. So this is a case where Mr. Barbulescu is employed, and his employer have these rules, which I've set out some of them, and the rules say that he mustn't use the firm's computer equipment or anything supplied by the employer for personal messages, which of course he does. He sends little messages on Yahoo Messenger, I'm not sure what that is, but to his girlfriend. Not very exciting messages, I'll be home late, let's meet for a drink, the little messages. The employers don't mention the fact that they're reading everybody's messages. They read them and say, oh, you've broken the rule, you're fired. And the courts say, well, he's broken the rule, you're fired. The Romanian courts, end of case, breach of contract, just a straight contract case. He goes off to the European Court of Human Rights, and they say, no, he's got a right to respect for his private life. And then they have this magic phrase, which I love, where they say, the employer's instructions, the terms of the contract, cannot reduce private social life in the workplace to zero. You cannot have a rule which says you can never contact your family or friends. That's just contrary to fundamental rights. There is no freedom of contract there. There's mostly freedom of contract, but you have to have some way in which people are allowed to have their private life. Pretty dramatic stuff, I think, because I think in America and Britain, employers always try to put something like this in their contract. Say you can't do all sorts of attempts to control your private life as well as your work life. Okay, so drawing to a close, I just wanted to give a few examples of why I think this constitutionalization of private law is a jolly good thing. I think it's a serious development in the law throughout Europe, and you've had a bit of it in the United States. I think on the whole, it could be a good thing, but it doesn't always work. We had a case about a field of sheep in Oxfordshire, which a farmer started putting his sheep on this field, which wasn't being used, and he did it for 20 years. But the real owner wasn't bothered about it because you can see it's close to the town, and the plan was that eventually he'd get, under the revised zoning laws, the right to build houses, and in the meantime the sheep were just cutting the grass, so it was fine. But he left it too long, of course. After 20 years, the farmer said, oh, actually, this is my property now, under the law of adverse possession, which I think you have as well. So it's my property, I'll develop it. I'll put the housing on. So the owner is very upset about this, surprise, surprise. We're talking millions of pounds here. And he goes off to the Strasbourg court. And much to my surprise, he lost. Because I thought he was going to win. He says, you know, I've got the right to private property. This is my property. The farmer knew it was my property. And but the court says, no, it's reasonable. After 20 years, you lose your property rights. But it wasn't reasonable. And our parliament, in fact, reversed the law on this particular occasion. Mr. Pay, hope this is not too racy for you. Mr. Pay worked as a probation officer, but at weekends, he ran a little business selling things like this, and he was making a bit of money on the side. But unfortunately, he had used himself as the model for these things. So the man in the white suit and the mask was him. And his employers discovered this and told him he had to stop. And he said, no, there's nothing to do with you. I do this at weekends. It's nothing to do with you. And they said, oh, yes, it is. This is very embarrassing. As far as I know, nobody knew apart from the employers. And anyway, he's fired, and he says this is interference with my private life, what I do at weekends, how I express my sexuality is up to me. You can't tell me what I could do. And the English courts say no way. They're very conservative, but so he has to go off to Strasbourg, to the European Court of Human Rights, and they say, yes, you're right. You shouldn't have been fired for this. But then he loses. They say, but you should have, effectively, they're saying, you should have had a bigger mask so people couldn't recognize you. If he'd done that, he would have been okay. This is another case about, so it's the right to get TV. This person these tower buildings were built so they could no longer get TV reception. So they complained, yes, would be an interference with their right to private life, not to be able to get TV. I think they would win, but under tort law they lost. They didn't have a right. I'm going to conclude with just a bit of jurisprudence, maybe for Anne's benefit, right? So what's going on here, I think, is the use of fundamental rights in private law. What's going on here is, in fact, what Dworkin was very keen on. This is a picture of Ronald Dworkin, who's a very distinguished legal philosopher. At one point, you probably should have a look at. I don't read everything he wrote, but read some. His famous article, Hard Cases, for example. And this is a picture of him at Oxford High Street, standing outside his college, University College. Across the street, you'll see my college, in fact. And this is when he was young and super trendy with his kipper tie and huge glasses. And what Ronald Dworkin said was this. He said, our duty as lawyers and the duty of the courts is to uphold the law, to uphold the rule of law, but everybody else has misunderstood, particularly somebody called Herbert Hart, has misunderstood what upholding the rule of law is about. And what you should do when you uphold the law is to uphold people's fundamental rights. That is the role of the judge. It's not to be a formalist, not to just enforce the rules. The thing you've got to do always, ultimately, is to uphold people's rights. Normally, it's fine. You just enforce the rules, the precedents, the statutes. Just enforcing the rules is fine, usually. But you always have to think, are these rules consistent with people's fundamental rights? And that's what I think is going on in this constitutionalization of private law. You enforce the rules, but you just step back for a moment and think, are people's fundamental rights being invaded here in a proportionate and justified way? And if not, you have to change the law. So I think we get to my last slide. So that's just a conclusion. And I also note in Europe, as well as upholding the rule of law as a system of rights, in Europe, that also means that it's post-national, this law, because our rights are largely derived from international treaties and conventions, which we tend to abide by, though I gather that's not de rigueur in Washington these days. So thank you very much for listening. I hope you've learned something.
Of you have class right now, so
Okay.
For those of you who can stick around, maybe Professor Collins has some questions, but I know a lot of you have to go, so please.
Yeah, I think they were ahead of.
Very good.
It was it. Yeah, but they've got to go to class.
Thank you very much. That's great.
But you understood it.
Yes.
Yeah. I was looking at their faces, and there were blank moments when they